In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
Now, I would like to invite on our virtual stage our General Secretary of IPNet, Mr. Parag Singhal, to introduce the chief guest for today, Dr. M.S. Sahuji.
Thank you, Namrata. Friends, I have the privilege of introducing to you all Dr. M.S. Sahu, a renowned personality in the insolvency ecosystem in India. Dr. Sahu, an authority on financial markets and regulations, is the founder of Dr. Sahu Regulatory Chambers. He holds qualifications as a company secretary along with advanced degrees in economics, law and management, and a PhD in economics. With an illustrious career spanning several decades, he has played high-impact roles, including Distinguished Professor at NLU Delhi, Chairperson of the IBBI, Member of the Competition Commission of India, Secretary of the Institute of Company Secretaries of India, whole-time member of the SEBI, and Economic Advisor to the NSE. As a member of Indian Economic Service, he served in key ministries within the Government of India. Additionally, he has served on the boards of several organizations, such as Oriental Bank of Commerce, Management Development Institute, National Institute of Securities Markets, Indian Institute of Corporate Affairs, National Securities Depository Limited, and Axis Mutual Fund Trustee Company Limited. As a chairperson of IBBI, Dr. Sahu spearheaded transformative insolvency reforms. He established the ecosystem and built its capacity, crafted the regulatory framework, and undertook advocacy, resulting in the swift and effective implementation of insolvency law, a historic achievement in India and beyond. He founded the IBBI, the first regulator of its kind in the world, and two pioneering professions, the insolvency profession and the valuation profession in India. These efforts earned India global recognition, with the country being named the most improved jurisdiction by the Global Restructuring Review in 2018. Moreover, India's ranking in the World Bank's Ease of Doing Business report soared, moved from 136th to 52nd in resolving insolvency within 3 years. Dr. Sahu has chaired several high-level committees and the frontiers of reform, such as on depository receipts, domestic and overseas capital markets, external commercial borrowings and valuation, devaluation profession, variable capital companies, international arbitration rules, insolvency law and competition law, all of which significantly shaped the regulatory and economic landscape of India. A dedicated advocate of knowledge sharing, Dr. Sahu has authored and conceptualized an array of publications, including Indian Security Market Review, NSE Research Initiative, Stock Exchange Factbook, SEBI Bulletin, NSE News, and Insolvency and Bankruptcy News. He also served as editor of the professional journal Chartered Secretary, His passion for integrating technology into education led to the creation of India's first online examination system, NSE certification in financial market. Solvency examination and valuation examination. He has authored over 500 articles in newspapers and journals. Over the last 3 decades, Dr. Sahu played a key role in shaping financial markets and regulatory frameworks in India. His lasting and significant contributions include the dematerialization of securities, the implementation of insolvency reforms, the design of regulatory architecture, and the integration of technology in education. He remains an influential voice, shaping policy discourse through his writings, interviews, and speeches. With this brief introduction of Dr. Sahu, I invite Sir for his keynote address on the topic of regulatory frameworks and compliance in the insolvency profession, key to ensuring efficiency. Welcome, sir.
So, good afternoon, everyone. Thank you, Mr. Singhal, for your generous introduction, and Mr. Makhija for connecting me with this distinguished group of insolvency professionals. This profession holds a special place in my heart, as I had the privilege of being closely associated with it during its formative years. I have deep admiration for the invaluable service you as the IPs render to our nation. Your work offers a healing touch to companies and individuals who are in distress, extending a much needed lifeline when one needs it most. Your services reach far beyond those immediate stakeholders involved. In fact, that helps in preserving and stability and resilience of our economy. In doing so, you often take upon stress on yourself to relieve the stress of entities and the stressed economy from stress, much like the Lord Shiva, who is said to have swallowed poison to save the world. Your dedication is truly remarkable, and I salute you for it, regardless of how the world may perceive you or the presence of a few black sheep within the ranks. The topic of today's discussion, regulatory framework and compliance in the insolvency profession, key to ensuring efficiency, is both timely and critical in the context of dynamic, evolving insolvency landscape in India. This requires us to note the vital role the IPs play in ensuring that businesses get a second chance while safeguarding the interests of various stakeholders, creditors, employees, shareholders, and even the broader economy, each with upon a conflicting rights and interests. To maintain this delicate balance, regulatory frameworks and compliance mechanisms must be robust, adaptive, efficient, and additionally, the processes must be transparent, fair, and firmly within the bounds of the regulatory framework. This significant responsibility rests squarely on the shoulders of the IPs, demanding meticulous attention to compliance and strict adherence to regulatory norms. Initially, as you know, the IBC did not envisage an IP to ensure compliance with applicable laws to the corporate debtor while acting as IRP or RP. But as the competence of IPs became evident, it got noticed. On recognizing their capability, Parliament amended the IBC on 6th June 2018 to formally entrust IPs with the responsibility of ensuring compliance with all applicable laws to the corporate debtor. So therefore, regulatory compliance is not something that should overly concern you. I believe this is the second nature to most of you. However, it is worth exploring the challenges you face in ensuring compliance and, more importantly, identifying the practical solutions that can enhance efficiency in your work. Let me first understand why is the regulatory framework so important to IPs. The answer lies in the nature of the proceeding. The insolvency proceedings are often complex, involving numerous stakeholders with varying interests, and these processes require a delicate balance of law, business acumen, and ethics. So first, a robust regulatory framework ensures that insolvency proceedings are fair and transparent. It establishes clear guidelines on how distressed assets should be managed, how claims should be settled, how resolutions should be achieved. This transparency builds the trust both among the creditors and broader market. A transparent process reassures stakeholders that no one is given a preferential treatment and that the resolution process will be equitable. Second, the regulatory framework serves as the backbone for maintaining the integrity of this insolvency profession. They outline the duties, responsibilities, and conduct expected of IPs. By adhering to these guidelines, professionals not only safeguard their reputation, but also uphold the credibility of the entire insolvency resolution ecosystem. Third, IBC places a significant responsibility on IPs to act in the best interest of all stakeholders. A sound regulatory framework ensures that IPs have a structured approach to decision making, which minimizes the potential conflict of interest and ensures that no stakeholder is left behind. Fourth, one of the core objectives of IBC is to ensure swift resolution of insolvency cases. A strong regulatory framework reduces the scope for unnecessary delays, providing clear timelines and procedures for various stages of insolvency process. And this promotes efficiency, reduces litigation, and preserves the value of distressed assets, ultimately benefiting the economy. Now, coming to compliance, regulatory framework is critical, but equally important also ensuring compliance. Without compliance, even the best-laid rules and frameworks lose their effectiveness. So first, therefore, the IBC mandates strict timelines for various stages of insolvency resolution, ensuring that value is not eroded over time. Compliance with these timelines is essential to prevent unnecessary delays. IPs play a key role in adhering to these timelines and ensuring that the cases are resolved efficiently. Second, the role of IPs beyond the technical competence part requires a high degree of ethical conduct. Compliance with ethical conduct is essential to prevent any conflict of interest and ensure that professionals act in the best interests of all stakeholders. And this is where the IBBI plays a critical role in ensuring that professionals follow a strict code of conduct. Third, the insolvency landscape is constantly evolving with new rules, regulations, precedents being set on a regular basis. IPs need to stay updated with these changes to ensure compliance. This is why continuous professional education or development, as mandated by the IBBI, is so important. It ensures that professionals are equipped to handle new challenges and can navigate the evolving regulatory landscape effectively. Another key area of compliance is accurate reporting and documentation. I have heard a few times Dr. Makhija emphasizing on this aspect. IPs are required to maintain detailed reports of their activities, decisions, and the outcomes of insolvency cases. This document is crucial for regulatory oversight as it provides a clear record or audited trail of how cases have been handled and ensures that all actions were in accordance with the law. Despite the importance of compliance, there are challenges that IPs face in this regard. First is the insolvency cases, complexity of the cases. They involve multiple stakeholders with a conflicting interests, which can make it difficult to ensure that all regulations are followed. In such cases, professionals need to have a deep understanding of both the legal framework and the business environment in which they operate. Second, while the IBC has significantly reduced the timeline for insolvency resolution as compared to the erstwhile times, the delays and particularly judicial delays remain a challenge, and these delays can sometimes hinder the compliance process as they extend the timelines for resolution beyond you planned and it creates uncertainty for the stakeholders. Third, as I earlier mentioned, the regulatory environment is constantly evolving. The new rules and guidelines are being introduced to address emerging challenges, and IPs need to stay updated with these changes, which can be a daunting task, particularly for those handling multiple cases. Now, coming to the role of the regulator, IBBI, which has a vigilant eye on the profession and insolvency ecosystem to ensure that insolvency profession is well regulated and compliant. And their responsibilities include, the IBBI's responsibilities include the ensuring that only qualified and competent individuals are allowed to practice as IPs, conducting regular audits and inspections to ensure that IPs are adhering to regulatory requirements, taking swift and appropriate action against them who fail to comply with the regulatory framework, ensuring that the integrity of the profession is upheld, and encouraging insolvency professionals to adopt global best practices which not only enhance compliance but also improve the overall efficiency of insolvency resolution process. Let me now touch upon the role of a technology in enhancing compliance and efficiency in the insolvency profession. The use of digital platforms for case management, electronic filing systems, AI-driven analysis tools can significantly improve the speed and accuracy of insolvency proceedings. Technology can help and is helping already the IPs manage complex cases by providing real-time updates, automated reminders for timelines, and secure storage of documentation. AI-driven tools can analyze vast amounts of financial data, helping IPs make informed decisions and identify potential risks at an early stage. And as an alternative to traditional litigation, ODR can help, online dispute resolution can offer a faster and cost-effective means of resolving disputes between the stakeholders and thereby improving compliance with timelines. Before I conclude, let me touch upon two specific compliances, or rather one compliance, and that is the specific compliance that holds a lot of promise for the insolvency outcome, and that is the section 66(2) of the IP code, and which most of the IPs do not give a serious thought or do not try to comply with. That provision makes the directors liable for the loss to creditors that arise during the twilight zone. And the twilight zone begins from the time when a director knew or ought to have known that there was a reasonable prospect of avoiding, there is no reasonable prospect of avoiding the commencement of the resolution process till the company enters the resolution process. And during this period, a director has an additional responsibility to exercise a due diligence to minimize the potential loss to creditors, and importantly, he is liable to make good such loss. This incentivizes the corporate debtor as well as the promoters and managers to seek resolution in the early days of stress when the possibility of a resolution is higher. Generally, when an avoidance transaction is avoided, the underlying property returns from the beneficiary to the corporate debtor. But section 66(2) is different. It provides that recourse against the director who made the transaction or during the time twilight zone when the transactions happened. So the recourse is against the director and not the beneficiary. The director is required to make good the loss even if he has not gained anything. This provision, to my mind, has been rarely used. And if this is used, if every insolvency professional discharges obligation under this section, no company would ever resist initiation of a CIRP, and in the process, the admission will be much faster. And I would request or rather urge my IP friends to assess the loss to creditors in the twilight period in every insolvency process and file applications for 66(2). And if this is done in a dozen cases, there will be no resistance to admission, and this will take out the incentive of the promoters to resist admission and enable the commencement of insolvency proceedings quite early when the chances of a resolution are high. The second one, not the compliance aspect, but how to deal with compliance, is that I wish to draw your attention to the Mobilux Innovations Private Limited versus Kirswa Software Private Limited, very early case 2017 or 18 from Supreme Court, where the Supreme Court held as regards the existence of a dispute under Section 82A that it clarified that what is material is that a dispute must exist in effect. It should not be spurious, hypothetical, or illusory, and it should not be a patently feeble legal argument or an assertion of fact unsupported by evidence. It is not material whether the dispute would actually succeed or not, and it is not necessary to examine the merits of the merits of the dispute at the stage of admission by the NCLT. So important, this has a lesson for all IPs. In fact, one must have an opinion that a dispute prima facie exists. So this is one sentence, that one has an opinion that a dispute exists. Now put the word prima facie. Where to put that? It is not that one has a prima facie opinion that a dispute exists. The placement of the word prima facie in the sentence makes all difference. Thus, you should distinguish the terms. You have an opinion and you have a prima facie opinion. These two are different. That a case exists and that a prima facie case exists. This is mostly used by the regulatory authorities. There are several. I'm familiar with the Supreme Court judgments in the context of the SEBI and the CCI. So in CCI, Section 26 talks that the Commission must have an opinion that a prima facie case exists, then only it can start the investigation. So a prima facie opinion implies that material collected up to that point meets the threshold required to justify further scrutiny. But a prima facie case implies that the material available up to that point meets the threshold required to justify the initiation of a regulatory action. Potentially, that may lead to penalties or other regulation actions. This should help you as a guiding principle when to act and when not to act in case of a doubt. So in conclusion, let me conclude that the regulatory framework and compliance mechanisms in the insolvency resolution are not just legal formalities. They are the bedrock upon which the credibility, efficiency, and fairness of the entire insolvency process rests. By diligently adhering to these frameworks, IPs do not only fulfill their responsibility to their clients, but also contribute significantly to the broader economy. As we move forward, we must continue to strengthen these frameworks, promote ethical conduct, leverage technology to enhance compliance and efficiency. Only then can we ensure that the insolvency profession remains a pillar. As you know, it was considered as one of the 4 pillars in the initial days by the finance ministry itself. There are 4 pillars of the insolvency regime. It remains a pillar of the economic stability and growth. Remember, whether it's the best times or the worst times, it is the only time we have. And at this moment, the IBC provides an unprecedented opportunity to us. Let's rise to the occasion and give our best to the nation. Thank you all for your attention, and I look forward to a fruitful discussion ahead. Thank you.
Thank you so much, sir, for enlightening us with your keynote address. We truly feel enriched. I would now like to invite our very own president of IPNet, Dr. Ashish Makhija ji, to present a formal vote of thanks and present a memento to our chief guest, Dr. M.S. Sahu.
Okay, thank you, Namrata. But before I do that duty of thanking the honorable chief guest, sir, if you permit us, are you in a position to take 1 or 2 questions from the IP, sir? Is that okay?
I'll be happy to take, but don't put me in a position that I defend an action of the IBBI. That question, I won't like to answer on behalf of IBBI.
Absolutely.
Then you ask any.
We appreciate, sir. So we'll, friends, anyone who would like to ask a question can just raise the hand so that we can see you and we will unmute you. But please make sure that not in the context of IBBI, in the context of any other thing you would like to ask. So please, if you want to ask a question, please raise your hand now. Anyone would like to ask a question to Dr. Sahu? Okay, so I think, sir, on everyone's behalf, I can pose a question, sir. Sir, if you are looking at the IPs, you have given a very important word, sir, that you have a special place for IPs in your heart. And I think that's the most important sentence which I could catch on. You started with that particular address, sir. What do you think, sir, the IPs should also do so that the not only I mean, within amongst our fraternity that we are recognized, but outside we should also be recognized that IPs are doing in this, I mean, the work which everyone should appreciate. So what should be done to bring that message to the outside world? So that's my exact question, sir.
2-3 things actually. One is, I think as compared to many other professions and as compared to the length of life of the insolvency profession, it's a 5-year-old, 7-year-old, and it is only 3,000 people who are active. Compared with any other profession, the visibility of this profession is much higher than many professions having 50,000 members, 1 lakh members, having 50 years of experience. So IP as a profession is visible, recognized, and respected already. One. Second is that the conduct, the reputation of a profession is built in its initial days. And it has actually, IP profession has already built a reputation, good or bad, depends on the person who is looking at. Of course, whose interest is affected, he would consider that this does not have that kind of a reputation. Like many people today say that IBC is not delivering. Those who have lost out their empires under the IBC process, they find that IBC is not delivering because they are losing out, their empires are going away. But they use lame excuses like recovery is 30%, 50%, many companies going into liquidation. So there are always a set of people who lose because IBC is a game of rights and interests and balancing their rights and interests, and ultimately there's a priority rule and you have to adhere to that. So those who lose it, generally they will have a tendency to say that something wrong with the IP profession, but not that I'm ignoring that. There are some black sheep always anywhere.
Absolutely.
So how it is, and the third is rather the advocacy part. Advocacy has 2 aspects. The one you told that IP net, that you have a kind of exchange of your ideas among yourselves. I had tried, actually I could not succeed. You encounter a problem. Is there a group of people with whom you can consult, and there can be a, like the UK has IP the practice standards, say IP standard 16, 18, 16 regulars that are pre-pack. So that means their standards are so important that the pre-pack process is conducted as per that standard and no law is required. So we need to reach that status. That means your IP network can have a 5, 7, 10 group of learned people. When any problem somebody comes across, possess that problem to that group. And then they give that this is the best way to go forward. If you have a record arrangement and like this, that a wise 10 people had advised this is the best way to go, and many people practice that, that becomes the standard and that becomes the rule of the game, and that will be respected by everybody, including regulator. But you have to have that kind of wise people to take a call. The second aspect is that advocacy. IBC, whatever it has worked, it worked because of the advocacy what IBBI and all people did. That's why I always say that the insolvency reforms is a reform by, for, and of the stakeholder. The kind of intensive advocacy engagements we had for 5-7 years initially, you need also that kind of advocacy to be recognized in the society. Thank you.
Absolutely, sir. In fact, sir, to give you a small background of IPNet, sir, we have created 11 study groups on a different subject where all the IPNet members can join, and we are having one meeting at least a month, and it is headed by 3 people, and then they're all members who can contribute and come out with their problems. So that is kind of how to do the routine matters. We are also, sir, in the process of forming an expert committee, as you also mentioned, and be ready, sir. I'm going to approach you for that also. So, expert committee we're going to form where we are going to set those standards. What you have said, sir, under your guidance and blessings, I think the IPNet will have to work. And insofar as advocacy is concerned, sir, we have also taken up that issue. And we have compiled, sir, what are the changes which are required. And we may, on behalf of the IPNet, we may take it forward to the government authorities. So I think, sir, Mr. Binay Singhania has been waiting. Binay, you have a question? Quick question.
Yeah. Good afternoon. It's a
Good
great pleasure to discuss with Sahu, sir. I'm coming to my question directly since we have lesser time. What I have seen that IBC has provided much relief to the banks, and of course is giving a good image for the country as well. But as of late, we have seen that promoters are there who are taking wrong advantage of the IBC. Like we have seen in a number of cases, companies are there which should not have been brought to the IBC, but they have been taken to the IBC by wrong way, and just to come out of the system, just to make the closure of the company, they have come in the IBC. Like if a company, say, promoter is there with 15 or 20 companies, and there are certain other liabilities are there which he don't want to make payment for that one. So one company is becoming OC for another company, and another company is becoming OC for the third company. In that way, they are bringing all the company to the IBC and directly taking to the liquidation, and after liquidation, they are taking it out. So how to stop all these things? Because one IP is not there for all companies.
Okay.
No, I don't think we can stop all the irregularities happening in the corporate sector or otherwise anywhere also. We have a limited role. Only when whatever is given to us, we will do our best. Many things are beyond us, but I am reasonably sure that the people who are doing, in fact, I think two IPs, they had brought to my notice 1-2 such cases where the defaults were manufactured to take it to the process, and thereafter to ensure that some people are forcefully given haircut and people escape their liabilities. And I think that IP pursued this matter and succeeded that CIRP should not have been admitted and it has been undone. So there are cases who do this, and there are also cases where IPs have been successfully able to nail these kinds of irregularities. But the important point is that important point is actually, I would say, is that the promoter, whosoever does this, does it under the guidance or advice of a professional, not necessarily insolvency professional. Some professional advises him that you do in this manner, therefore you can do it. So it is important that, because the professionals, I always consider, they are doing a function, a state function. I consider it as a secondary state function on behalf of the state or government. So therefore, every profession, not only IP profession, every profession has a duty that they are doing a duty in public interest. They must not be used by someone to be their partners in their whatever way they want to do. And I think in this context, I used to quote a sentence from Mr. Prithi Holdia that every professional is not a scamster, but behind every scam, there is a professional. So I think it is a duty on all professionals, not IPs only, and IPs are too small in the sense 3,000-4,000 people only. But we have, if you take all professions together, it can be millions. So every professional has to behave as a really a professional because you have been given a state duty. Thank you.
Thank you, sir. I think your wonderful words of advice that it is the conscience which actually speaks. So even the professionals must look at their conscience and advise in the right interest and the right path. Friends, I think I know there are a lot of questions, a lot of people have raised hands. Sandeep, I have to take, apology to you because I think we have got a speaker and we have to give him time also. We will actually, I can assure you, if Dr. Sahu permits us, we will have an interactive session sometime, if that permits us. So, but right now, I think let me present as a formal vote of thanks to you. So your opening statements were quite refreshing. And I must say, sir, the entire keynote address was completely mesmerizing. I was mesmerized, sir. The words are still echo in my ears. Special place for IPs in my heart. I think this is a wonderful statement, and every IP would be very happy to hear this. And you said that you admire the dedication of the IPs, the role they are playing towards the nation building and economy. And also, sir, when you emphasize the following the strict code of conduct, the importance of maintenance of the records, and also adapting the technology. I think these are the three key points, takeaways, friends, which we can take us. And of course, insofar as establishing the credibility is concerned, he says no legal framework is required. The credibility lies within us, friends. If we resolve within ourselves that we would like to work in a completely ethical manner, I think the profession of insolvency profession will definitely grow. Sir, on behalf of the entire team of IPNet and on my own personal behalf, I would like to extend heartfelt gratitude for your insightful and a thought-provoking keynote address on regulatory frameworks and compliance in the insolvency profession, key to ensuring efficiency. Sir, your deep knowledge and expertise has greatly enriched the session. It has left a lasting impact on all attendees, and your address completely has provided clarity on challenges of the regulatory compliance and has also paved way for the meaningful discussions on how insolvency professions can overcome these obstacles. Sir, we truly appreciate the time and the effort you dedicated to joining us as our chief guest. And sir, we look forward to your continuous guidance and support in all our future endeavors. Thank you, sir, for your invaluable contributions. Sir, before you leave, we would like to present you a memento. We are showing that it is on screen, but we will send you the physical copy in a day or two, sir. So this is, sir, with folded hands, sir, we request you to please accept this memento
Thank you so much.
on behalf of the complete IPNet fraternity, sir.
Thank you so much.
Thank you, sir. And it was a wonderful occasion to have you here, sir. Sir, if you have any other engagement, we know that you have a lot of engagements. We will not hold you. If you would like to stay, sir, and here, we are most welcome to do, sir. Thank you so much, sir. It's our pleasure, sir.
Thank you. Bye.
Over to you, Namrata.
I would like to once again thank our chief guest, Dr. M.S. Sahu ji, and our president of IPNet, Dr. Ashish Makhija. With this wonderful beginning, we come to our session of the day. Our speaker for the day, CA Udayraj Patwardhan ji. Over the past 7 years, he has emerged as a distinguished speaker, leveraging his expertise as an RP and liquidator for more than 48 assignments. Additionally, he has contributed to over 150 assignments as an advisor, managing a debt resolution portfolio exceeding 25,000 crore rupees. He is a partner in CA firm Palnitkar and Patwardhan, established in 1999. He's also having Sumedha Management Solutions Private Limited, which is an IPE, via Jur Advisors Private Limited, which is an advisory firm. His educational background is he's a fellow CA, BCom rank holder from Pune University, Master Business Finance rank holder, and a law graduate. His areas of specialization are in diverse domains, including management consultancy, corporate advisory, financial and commercial advisory. His expertise extends to strategic areas such as corporate expansion strategies, mergers and acquisitions, succession planning, providing insights into commercial litigations and arbitrations. Accomplishments include, he's recognized by the World Bank as a master trainer for IB Insolvency and Bankruptcy Code, accomplished speaker addressing professional gatherings at IBBI, IPAs, and banking forums, trained as a master trainer for IBC. He's serving as a visiting faculty in Maharashtra Police Academy for PMLA, which is the Prevention of Money Laundering Act, Benami Properties Act, Black Money Act, Importance of Audit in Cooperative Societies, Frauds in Cooperative Sector. With this, I would request Udairaj Patwardhan to kindly take over as the keynote speaker for the session. Uday sir, you're on mute.
Yep, thank you. Thank you, Namrata, for the introduction. At the start, let me start with a very frank opinion that we all have worked with seeing the work of Dr. Makhija. Like a son, he would do his work and we all learn from whatever he's doing. He will not discriminate who gets his knowledge, who will not get his knowledge. So that is how we have been looking at him. I personally have been looking at him, and this opportunity of sharing some of my thoughts with you all fellow professionals was a very good opportunity. I thank Ravin Chaturvedi and Namrata for that. So with this small start, let us look at what we want to do today. The topic that we want to see or we want to look at is a very vast one. What we want to look at is the regulatory compliances, the problems and the solutions. Now, when we talk about regulatory compliances, generally people expect form filing, returns filing, etc. to be compliances, which in its short terminology is very correct. But as you see and look at the IBC, the whole of the regulations that have been set up are completely a set of compliances for us. The moment we give our consent in Form 2, till the CIRP is completed, or in case of liquidation, when we give our consent to the dissolution of the company, every act that is specified in the regulations and the code is a compliance. So if we start about talking of all these compliances and any problems that we faced through the compliances, and also the reporting of the compliances in various CIRP forms 1 to 7, new liquidation forms from 1 to 4, voluntary liquidation forms 1 and 2. So all these forms are basically kind of reporting for data collection and checking of milestones by IBBI. They are not the compliances. The compliances lie in the acts that we do on day-to-day basis. With this in background, we will try to focus on to certain areas, 3-4 areas, because we have a very limited time today. And with IPNet being in place, we will have many more opportunities on our monthly meetings, daily evening sessions to discuss many issues. So let us try to focus on 3-4 issues on which we will have 10 minutes discussions. What the setup right now decided or conveyed to me is we will have a question and answer at the end of the session. But if we have any very specific input or question, we will take it up very quickly. Moderators, please look at that. We have Bharti Daga as moderator, and I thank her for being there. So moderator can look at the questions which could be there at the chat box, etc. We will take it up. If I am not able to address it satisfactorily, there are many other learned professionals and also Dr. Makhija here who can always address that. So what we will try to look at first is the first thing that is looming on our head. What is looming on our head right now is the date of 30th of September. Now, 30th of September, when we talk about as a company secretary or as a chartered accountant or as a cost accountant, it is generally the audit date, the date for filing of tax audit. Of course, those are the compliances that we must look into. We will look at that in the latter part of our discussions. But first, we have to look at the circular issued by the IBBI that liquidation forms 1 to 4 have to be filled in by us, failing which we will be in default we will not be allowed to renew our AFA, and there could be action taken against us. So what are these 4 forms? We all must be knowing it. I will just quickly go through it and address it. And then if there are 1 or 2 questions, we will take it forward. So let us look at what these forms are. Allow me a minute to just dig it. Yes. So the circular was issued long back on 20th of June, and they say that you should file 4 forms: liquidation 1, liquidation 2, liquidation 3, and liquidation 4. How are these forms, or what do they cover? Liquidation 1 form is required to be filed from the commencement of liquidation, that is liquidation commencement date, till public announcement. This includes details like who is the liquidator, who is the corporate debtor, and what is the liquidator's fee. So liquidator's fee, as you all are aware, is fixed generally by the COC in the meeting in which liquidation is proposed. So that is required to be stated here. And the timeline in future for this form will be on and before the 10th of subsequent month after public announcement has been made. So if the liquidation starts, say, in September, and you make the public announcement in September, then the form will be filed by 10th of October being the last date of filing the form. In any new form that you file, we have seen that there could be some technical issues, some questions, etc. And we have seen that IBBI is very prompt to reply to that. But with IPNet in place, any issues that we will face in filing the forms, if you have not started filing the forms, I would suggest and request the IPNet team to set up at least 2 evenings for discussions on filing these forms, so that any problems in the filing of the forms can be discussed in the evening before 30th of September. Then we have liquidation 2 as the second form, that is from the public announcement till the first progress report. This will include the details of valuation, sale, litigations, PUF transactions, SCC meetings, receipts, payments, etc. Again, that is to be filed again on the same date, 10th of the subsequent month after submission of progress report to AA. So we file progress reports on quarterly basis and the final report on an yearly basis. Liquidation 3 is the third form, which is from the last progress report to application for dissolution. So that is the area that it will cover. This includes details of unclaimed proceeds, sale, litigations, PUF realization, etc. Again, the date is 10th of subsequent month. And the last form is the application for dissolution to order for dissolution. So as soon as you file for dissolution, then till the order of dissolution is passed, that period will be covered, and it will include again the distribution of proceeds, receipt and payments, etc. And the timeline or the timeline given is 14 days after the passing of the order of dissolution of the CD or closure of the liquidation process. Now, these are the normal forms that we will have to file every time on month-to-month basis. And those cases which are already in place or already running, they will have to file liquidation form 1 and liquidation form 2 before 30th of September this year. So with this brief background, if you people have filed the forms and if you have any queries on this, let us take it up those queries so that this chapter will be over. We will take up queries for maybe next 5 minutes and then we can proceed. Bhartiji, if we have any questions, I think we shall take it rather than accumulating all the questions at the end. Let us give 5-7 minutes for this liquidation provisions.
So my request is we can, because I can request the members to please raise their hands if they have a query, or if they are posted in the chat box, I'll request Bhartiji to please read out from the chat box so that you can take up the questions. I think there are a lot of questions which are coming on chat box. Bhartiji, if you can just read and one by one. Bharti, are you unmuted? We have sent you a request to unmute yourself.
Yes, sir.
Yeah, please go ahead.
I can-
And don't mute yourself, because once you mute, you will not be able to unmute. Okay.
Oh, okay.
Yeah, just read it and
So
help.
there were, yeah, I shall take one question, that is liquidation form to be filed for March and June quarter or only for June quarter before 30th September. So the question is from Mr. Rajesh Jhunjhunwala, who's asking which all quarters we require to file the form for the before 30th September.
Okay, so for the ongoing cases, that is cases in which no application for dissolution of the CD has been filed, shall file liquidation 1 and liquidation 2 for March 24 quarter by 30th of September. So I will repeat again, we will divide it into two parts, where cases which are ongoing and cases where application for dissolution has not been filed. In that case, for March 24 quarter, liquidation 1 and liquidation 2 has to be filed by 30th of September. That is first case. Then the cases where application for dissolution of CD has been filed. In such cases, the forms filed shall be for the last quarter of the process, which is the June quarter, and that shall be filed liquidation 1 and liquidation 2 for June quarter shall be filed. So that is where application for dissolution has been filed. And additionally, liquidation 3 has to be filed by 30th of September. So where cases where application for dissolution has been filed, that is, the case is almost over now and you have gone for dissolution, then 3 forms have to be filed. Liquidation 1, liquidation 2 for June 24 quarter, that is first quarter of the financial year or second quarter of the calendar year. And additionally, liquidation 3 form will have to be filed by 30th of September. The date will remain 30th of September only. Then we have cases where order for closure of liquidation process or dissolution has been ordered. In that case, all 4 forms will have to be filed. That is first case we discussed, where the process is going on and application for dissolution is not filed. Liquidation 1, liquidation 2 for March quarter. Second case, the application for dissolution or closure has been filed, but order has not been passed. In that case, liquidation 1, liquidation 2, 2 forms for June 24 quarter, and additionally liquidation 3 form, all will be filed by 30th of September. And the next case is a case where order of closure of process has been ordered. In that case, liquidation 2, liquidation 1, liquidation 2, both for June quarter. Additionally, liquidation 3 and liquidation 4 also has to be filed. So this is a simple division that has been given. You can refer to the circular, para 6. It explains this process very, very clearly. And please remember that they have put up a very specific warning that IPs who do not comply with the applicable provisions shall be liable for failure to file a form for relevant information, that is under section 196. IBBI can call for data, records, etc. If inaccurate or incomplete information is filed, that is also not correct. So don't do like you are not able to find some information, you put in some information and submit the information, like your fees you have not calculated properly. You put in approximate fees of the liquidator. Don't do that. Whatever you need to do, start working from today. You have enough days in hand and complete filing of the forms in time. I think I have addressed this question. Any other question?
Yes, sir. Thank you very much for the answer. The next question is from Mr. Rajendra. He is saying that is there any form to be filed with regards to bankruptcy trustee? Query has been given to IBBI, but no reply had been received. Rajendra ji, is this the question that you were trying to ask?
Bharti, you can just go on because he's muted, so he will not be able to answer it.
All right. So Patwardhanji will be able to take this question.
Yeah, we can take this question. As so far as the compliance forms are concerned, they are not notified yet, but I will take up the two specific forms which we are required to file. Just allow me to dig in my data for a minute.
Yeah, Patwardhanji, this is a problem which is coming because you see, as far as appointment as an insolvency professional in individual insolvency, again, there is a problem which form to be filed. So naturally, I think they have not notified the form so far. Probably the problem is coming.
No, they are not notified the forms yet.
What should be done? I mean, that question is, in case the forms have not been notified, what should the IP do under such circumstances?
No, again, my personal view, not even a professional advice, is we have seen the whole process from 2016 onwards till today, when we did not even have regulation 36A, 36B, like you did not have to put up an advertisement out there, etc. From today, we are in a very regulated environment. And the forms that we file are basically the forms for collection of data. They are to be filed on occurrence of a particular event. So that does not stop the RP or the bankruptcy trustee from working. The working shall continue and the data shall be accumulated and prepared in a particular manner. According to me, a progress report can be prepared and filed with Honorable NCLT separately, including these information that we normally would file in our reporting forms. So that would be my suggestion. That can be done, but IBPI at present is not equipped with collecting that data, at least in case of bankruptcy trustees. That is what my reading is.
Thank you very much, sir, for your insight. There is one more very interesting question asked by Mr. Manoj Kumar. He's also raised his hand. Can they please unmute him for the question? Because he's got a question which is a very typical and I want him to ask himself.
Yeah, sir, my question is, I have two questions. One question is there that, in one of the PG to CD cases, the particular PG has gone abroad, settled abroad, now doing business abroad. We need to issue public notice. The relevant regulation says it should be issued in the state where he's residing and where he's doing this thing there. In case of a person, for example, he has gone to Singapore, should we take step to issue notice at notice in the newspaper, I mean to say, in that particular country also, or if yes, then what is the procedure for that? This is my first question. Let me understand this, reply to this, then I shall move to second question.
Okay. Again, my personal view is when we are dealing with any cross-border insolvency matters, when a person travels to another jurisdiction, that person as an individual, we have to differentiate between an individual and a corporate entity. Corporate entity cannot travel outside, but individual can travel outside into a jurisdiction. Company will remain in the jurisdiction where it is registered. That is the concept of QAMI when we talk about. But in case of individual, that is not possible. So if a person travels to another jurisdiction, the resolution professional going ahead and publishing the notice in a different jurisdiction will be beyond the legal capabilities, one, of the resolution professional, two, of even the NCLT that we are subjected to. So it will not be possible to go beyond where we are. However, if we approach the courts in that jurisdiction with the permission of the NCLT, we may be able to publish an advertisement there, but you will have to follow the due process of law by approaching NCLT here, then the appropriate jurisdiction in that particular area. And now when we are talking about Singapore, we are talking about a jurisdiction which is fairly developed in case of insolvency. But let me ask a question to myself. Had it been in Cambodia or had it been in Kenya, what would have I done? So these questions remain, and I keep asking that question to myself. For anybody who has gone out, how do we tackle that? We see that in case of Vijay Mallya or others who are in London, we are still facing issues in bringing them to the insolvency umbrella. So that is the situation that we see. I
Okay.
hope I've been able to answer a little bit, but anybody wants to add, please go ahead.
Okay, Mr. Patwardhan, if you permit me, I can add a bit to it.
Yes, sir. Yes, sir.
Okay, Mr. Anand, what you need to do is like this. The proceedings have started in India. And what is the basis of
Yes, sir.
Yes, what is the basis of starting the proceedings in India? That means there is an address which was recorded address. He has some permanent address in India. Therefore, you started the proceedings and NCLT admitted it. So you will have to publish the advertisement in that jurisdiction only. There is no, obligation of the RP to publish in US or America. There is no jurisdiction, as Mr. Patwardhan also very rightly said. Now, having said that, assuming now you publish and he does not cooperate, now we are coming to the second step, right? Naturally, he will not look at it and those kind of things. If he is not cooperating, then what do? Then you can approach back the NCLT. NCLT can direct. They can actually give you powers to write to the Consulate of India in Singapore. So the process is like this. Typically that notice will be served upon him through the Indian Consulate in Singapore. It's a long drawn process. It has never been done under NCLT, but I think you can set a precedent. So if you have any questions, we can speak offline and we can talk about that. Okay, now your second question, please.
Sir, isme I would like to add that what I did. There is a one MCA circular which stipulates what you are saying exactly, that it should be done through a relevant counselor or something like that. Although that circular does not mention about IBC, but because they might have not taken care for the IBC, but it mentions about company law, income tax, and all this thing there. So it is in consonance with what MC also think. This is my addition.
Correct. Chalo, great. Thank you so much.
Okay, my second question is that we are a little bit confused that now in the case of liquidation under section 31A subsection 9, voting is done, present and voting is there. Concept of present and voting is there, which is not for CRP cases. Present voting concept is absolutely clear to everybody. I won't repeat it here. In that present voting concept, if anybody is showing as abstainerism, it happens that he was present in the voting, but he voted as abstainerism. Will that abstainerism be counted in the denominator and numerator for the purpose of calculation of passing of that particular voting or not?
Okay, Anandji, this does not pertain to regulations, but I will still request Mr. Patwardhan to answer it. We're talking about
in case
compliance.
of any voting, whether present and voting or otherwise, the denominator is always the eligible voters. So if in the meeting the person was present, that person or the stakeholder was eligible voter will be included in the denominator. So that is mandatory, whether, as I said, in present and voting or total voting. Whenever you are eligible for voting, that is in the denominator. And those who abstain or who go against the resolution, of course, you will have to count only the votes which are for the resolution. And if, for example, you have 30% voting for, 20% abstained, and 50% voted against, so the resolution will not go through because it has garnered only 30% votes for the resolution. So that is how we will count it.
Thank you very much, sir. There is another question by one Mr. Sanjay Borad. When an RP is appointed by the NCLT by replacing another RP and the CD is in the stage of resolution plan, what form needs to be filed? Because as of now, according to him, the RP has not handed over or shared any data about the resolution plan process.
I did not get the question. There is
there is a replacement of the RP.
And that is fine. The replacement happened, and within 7 days or so maximum, the handover would typically be complete. So
yeah, but the RP has not yet given.
Practical question.
So the RP has not yet given the handover. So how does a new RP get appointed, file the form for the resolution? At the time,
as soon as the new RP is appointed, that person is in charge. And if he is not able to comply with filing of the forms, that will be delayed to that extent. We have seen such cases when the handover is delayed for one reason or the other. In such cases, filing of the forms by the RP may get delayed. Even penalty could be imposed of 500 rupees or whatever the charge for the delay per month. That will have to be paid. Some things cannot be avoided. But filing forms should not be the only worry. The worry should be the handover not being complete and the RP not being able to take the resolution plan process ahead. Filing and reporting is secondary to the main compliance that we have to do. So if the resolution plans have been received, hypothetically, then the duty of the RP would be to present those resolution plans before the COC under section 25 and start looking at those resolution plans, start inspecting and seeing whether they are compliant with section 30, regulation 38, 39, etc. So if that work is getting hindered, then the next step will have to be taken. But filing forms with IBBI is a secondary thing. If you don't have data, you cannot do anything. You will have to collect that data information and file those forms.
Thank you, sir. Thank you for the clarification. There is one question from Mr. Praveen G, which says, if the liquidator has changed about 15 months back, who is responsible for filing the old liquidator or the new liquidator?
Ma'am, can I interject here, please? Because we are actually going out of the subject. We are unfortunately going out of the topic. We were here for regulatory compliance, but I think people are raising their personal issues. My humble request is that let us stick to the topic we are discussing today, sir.
Let us come back to let us take up the question of the liquidator having been changed 15 months ago. And who will file the form? According to me, liquidation 1 and liquidation 2 will be filed by the current liquidator. Old liquidator has lost all his rights to report anything to any authority. Present incumbent on the seat will do the compliance because the compliance is to be done today. However, this is subject to interpretation. This is a form which is of a particular event. What they want you to do is file liquidation 1 and liquidation 2 based on the progress report of March. When you talk about 15 months ago, that liquidator did not do your March 24 report, you did it. So there is no question that you shall file liquidation 1 and liquidation 2. That is my understanding.
Thank you very much, sir. And I request everybody to now let's proceed to the next topic, and sir can take the next topic ahead.
Yes. What we look at next point is there are 7 forms under CIRP 1, 2, 3, 4, 5, 6, and the monthly form CIRP 7. And almost everybody is filing CIRP 7 according to me, because you don't have a model CIRP case running exactly as per 40A. If there is some, I would suggest IPNet कि उनका एक चौक में जाहिर सत्कार करना चाहिए जिनका 40A के अनुसार बिल्कुल CIRP चला. I have seen nobody. Initially, when the processes started, maybe we could complete processes in 165, 170 days. I remember that it happened in 2017-18, but now there are delays in running the process, and that unfortunately continues. So let us look at the issues in Form 7. I will just quickly run through Form 7. You all must have filed it multiple times. Just allow me a minute to just run through it. And then if we have any queries on it, we will take it up. Otherwise, we will move to the next topic. Only 1 minute, allow me. So what the title of CIRP 7 is very typical. It's about reporting the status of ongoing CIRP, and that is done through CIRP 7. So first regulation 40A came in, and thereafter this form 7 came in, so that they are able to see as to what is that is not happening as per the regulation 40B. So with that in mind, form 7 has basic details like the details of the IP, etc., and the corporate debtor, the assignment, the scene of the corporate debtor, etc. Now comes the question of status of CIRP. First question that many people get stuck at, dates from ICD. Now the question that will always be asked is, how do you count the dates from ICD? Everybody has its own interpretation, basically regarding the exclusion and the extension that has been granted. So my personal opinion is the exclusion that has been granted would be excluded and the extension will have to be included. However, when it was to be filed manually, when it was introduced in 2021, it was easy to write down and file certain things. But today, when you are filing it electronically, you may get hit by some software glitch that you might be required to put in the complete days, day 1 to day 100, whatever are the days you will have to count, and you will have to report it. Then there is the most important question as to why are you filing Form 7? So there are 5 events that they have specified that you could not make public announcement in 3 days of appointment. Now the question many a times is asked that the order is dated say 14th of September. The order is actually uploaded on 17th of September, and then same day you receive it and you do the public announcement within 3 days. So you do the public announcement say by 19th of September. So they will still count 14th of September as date of pronouncement and appointment of IRP, because that is the date of the order. So you may end up paying penalty in such case. So such issues do come up. Some IPs do state that start of CIRP itself is 17th of September, but that according to me is not right. But if you put 14th of September as start of CIRP, you will invariably end up paying penalty for that. Second question is, RP not appointed within 40 days of commencement of insolvency? Is flat, no problem. If the IRP is not confirmed, the present IRP or the new one, no issues. Then IM is not issued to the COC within 51 days. Now comes the important question that the IM is ready with the IRP, but the confidentiality undertaking is not given to you. Then within 51 days, you are not able to issue because the confidentiality undertaking came to you only on 60th day. Then again, you are penalized because you did not issue the IM on time. That is also not appropriate. In such cases, the solution is you have to run after the COC and see to it that the confidentiality undertaking is given to you. Some IPs state that issuance means ready for issuance. I will actually hand over when the confidentiality undertaking is given to me. So many IPs do such interpretation that I issued. They could not receive because they did not give me the confidentiality undertaking. So many IPs take that view as well. Same RFRP is not issued within 51 days of IM. The reason could be the terms and conditions were not approved by the COC. So the RFRP, even if it was ready with you, not approved by the COC, the terms and conditions, the EMD, etc. Again, it is dependent upon the response of the COC in multiple cases. And the last one is almost common in most of the cases, CIRP not completed within 180 days of commencement of insolvency. So these are the 4-5 things that we have to state. Then the reasons for the delay are required to be given as to what happened exactly, and the status of COC to approve the resolution, withdrawal, etc., etc., and then the remark to be provided. So this is a very important form. Please remember that filing CIRP 7 on month-to-month basis, don't do it mechanically. You may be asking your staff to fill in the information and complete it from month to month, but at least every month when the form is being filed, please have a look at the form, see whether the situations or circumstances have changed and whether the replies given in the form need to undergo any change. So only these 3 things I will request you to look at. And if there are any queries on Form 7, let us discuss that.
Yes, sir. There is a query from myself only. If I could ask you a question. So my case was, sir, that the IRP was appointed and he didn't do any work. So the COC finally decided to change the IRP, and I was then appointed as the IRP after 135 days. So because it was after 135 days, the IBBI gave me a query that you have to file section the CRP 7 because after the appointment you did not file it in 3 days, the publication of the advertisement, and accordingly I was made to pay the whole of the thing. I explained to the IBBI officials that I was not the RP at that time or the IRP at that time, but they said that we will see later. First you do the payment and file it, that you have not been able to file it because of whatever reason, and upload the order, and we will see what to do on that. That was my
Yes. So there are
happened?
two questions. Yes, I would suggest that what you have to do. Sometimes there is no option, but the process to complete that is very, very important. I would suggest that in such cases, first thing that the RP who has been appointed should do is write to the IRP and state that 1, 2, 3 things you have not done. That is why the CIRP 7 was required to be filed, which you have not filed. Kindly explain. He may reply, he may not reply. Bring it to the notice of the COC that I have done this and now I am required to file this particular form in this particular fashion, and then file the form. So nothing is going to save you from filing the form for delayed publications, etc., etc. That will have to be filed. If the IRP doesn't file, IBBI may say you only file it, and you might be required to file that also. But in such cases, the communication with the previous IRP and bringing it to the notice of the COC is very, very important. Also include that particular fact in the progress report that you have filed, that this is how you have maintained the sanctity of the process and complied with filing of those reporting forms, etc. So that can be only solution that I can provide. But if you ask me whether I can avoid payment of penalties, delays, etc., that will be left to the IBBI. I have seen that in some cases, when a request is made for a refund of such penalties, that is granted also. So don't lose hope. You can do and request for a refund of any penalties that has been paid, and sometimes IBBI refunds that money also.
Thank you very much, sir.
Bharti ma'am, sorry, I'm interrupting you. Some Rajesh Shah and some Jain who wants to go for Chatur Vihar. If we can take their question first, that will be great, ma'am.
Sure, sir.
Yeah.
Sir, I think we can unmute them because I can't see their question. They haven't posted it.
Bharti, this is Rekha Shah. I have posted the question.
Yes,
Am I
Rekha
audible?
ji. Yes.
Yeah,
You can speak, sir. Ma'am,
Yeah, see, when in the case of liquidation forms which we need to fill in as per the circular June 2024, when it comes to liquidation form 2, it starts with Jan to March 2024. That is the first form we need to fill in. So when we fill up the
Yes.
data with related to the receipts and payments, there are 2 columns. One is for the quarter and the next column is cumulative. So the moment we fill up the data for quarter, it gets auto-populated to the cumulative also. And the cumulative column doesn't allow us to key in the numbers as in like cumulative till date. It just takes up the data from quarter as a cumulative number. So I'm not very sure whether this is correct or not. I have raised this query with IBBI, but I'm still awaiting the response. So any idea if any of you have filled in?
Yeah, I have again filled in multiple cases of mine, and I have seen that this problem remains, and IBBI is yet to come back with the reply. What is happening at IBBI's end is the people who are giving us the reply are basically people who are resolving the technical issues. They don't really know what your progress report means. So they are checking with the team of liquidation as to what should be the logical reply, because they are only solving the problems in the software glitch if there is any. And here certainly is a software glitch, because what is expected is you should file the forms for the quarters quarter 1, quarter 2, quarter 3, quarter 4, and in the fourth quarter it will be cumulative. But in this present form that is being filed, the quarterly information we are not able to keep away from the cumulative one. So the reply is still awaited from IBBI. Yes.
Yeah, and it should not be the cumulative, should be from the date of LCD till date. It should not be
Yes.
based on the financial year.
No, it is not. It is from the start of LCD, that is LCD to the last date of the quarter.
Correct.
Sir,
Okay,
I
thanks,
may
Udairaj.
intervene here. When I filed my LQ2 with the March report, so in the March report, I had taken the cumulative figure up to the March, because for March, when we are filing, we have to take all the expenses up to March. And then when you file the June, it gives you the cumulative for March as well as for June when you add the June on.
Yeah. Bharti, exactly. See, this question I have posted only for the purpose of ongoing assignment. While the companies which I have handled where the CD has been dissolved and the order has been issued, I have done exactly the same, because there is only one liquidation form you have to fill in. This is not a quarter to quarter wise. So I actually, in the quarter itself, I have submitted for the cumulative and it gets auto-populated, because it's like, based on the final report you fill up. So that's how I close assignment. But I thought
only the areas which are covered under 6B. That is correct.
Yeah. So let IBBI answer for this. Because
Yes,
to
and
my
whenever-
understanding, the moment you go for a next quarter reporting, it gets auto-populated in the next quarter reporting. It takes up the data from your previous report.
Yes.
So that's why
Yes.
it is more critical. Yeah. All right. Thank you.
Okay, Bharti, my request is that what are the points to be taken up with the regulator, IBBI? Just please make a note of it and send it to us. We will definitely, from IPNet, we will definitely be very happy to take it up with the IBBI.
Okay, sir. Definitely, sir. There is one question from Raj sir also, and he has also raised his hand. I would request somebody to unmute him so that he can ask the question. It's on liquidation form.
Yeah, request has been sent. He has to accept that unmute request. So he has to mute.
Raj sir? Raj sir, could you unmute?
Yes, sir. Yes, sir. Ashish, my question is that I have been replaced as a liquidator, and the erstwhile liquidator was conducting this process for last 5 years. I am just 3 months old. So in such case, who to file this liquidation form 1 and 2?
So I have tried to address this. The old liquidator is no longer in the seat. So he has legally no authority to
But the
comply
basic
any forms.
information which the form is wanting is being done all by him. So under my form, how I can write that what was there in preliminary report, what was there in asset memorandum, how to compile all those progress reports?
Whatever has been done by the earlier professional, you are adopting it completely and taking it forward. In the whole process for the stakeholders, it does not matter who is the liquidator. Liquidator 1, liquidator 2, liquidator 3, all are the same for the stakeholders and for the law. We cannot divide the work done by liquidator 1 against the work done by liquidator 2, etc. That is not possible legally. So it is not about taking responsibility here. It is about filing the information. So to safeguard your own interest.
Sir, got your point, sir, absolutely. But what if that there has been several...
if you are trying to save or safeguard yourself, what you can do is get it verified by the earlier liquidator that this is the information that I confirm. And based on that confirmation, either on my email or by a document, you can adopt that information and file, so that you are not in a position that you created some information out of your own knowledge. That is what I can suggest. But you may not be able to ask that liquidator to come and file the forms. That might not be possible.
No, my problem is something different. There has been several non-compliances by the erstwhile liquidator, and due to which I am not able to fill many of the clauses required in the form. In that case, what should I do? Because in that case, if not done,
you should identify. I agree. This should not end up being a case of any investigation. I agree. But in such case, what can be done is you should identify those issues and communicate to that particular liquidator that these are the issues which I have come across in filing the forms. kindly explain or help me in this particular regard. Just on a lighter note, ChatGPT is a very good tool to convert in a very hard sentence into a very soft sentence and ask him the question very, I would say, in a very good language to that person, even if we are very angry about the work done or not done by that particular person. But you should put it on record as to what information you did not find, what are the non-compliances, how they have been done, and what is the explanation for that, so that you are not held responsible for that. But it will have to be reported to IBBI. We cannot go away from that. And in fact, the regulator wanting such forms to be filled in, the main reason is what happens with the liquidator, what happens with the RP. They don't know unless we file those forms. We may feel that IBBI is aware of whatever is happening, but they are not unless we file form CIRP 127 or now liquidation forms. Till that point, unless we report, they are simply not aware what is happening here. And all the questions from the legislature to assembly and everybody, the government asks questions only to IBBI and they are helpless. So collecting information about non-compliances from previous liquidator, etc., please take it on record so that you are not held responsible for that.
Sir, also to add, every form at the end, they have some other remarks. If you want to say anything, you can
Yes.
put your foot there as to what was your issue while you do the reporting.
But I would always suggest that before you write anything there, write to the other person. It is always
Yes.
necessary in any
Yes.
legal correspondence to ask the other person what do you want to say.
Yes.
And then you write whatever you want to write. You don't assume circumstances and don't judge the other person without knowing what happened, what went wrong, why did things happen. So that is with you. Thank you.
So we can move to the other topic.
Yes, now we have to quickly touch upon two more topics which I had in my mind. One was discussions on Regulation 31A about the regulator's fee. So many people are facing questions about how to calculate the regulator's fee, etc., and whether it will be CRP cost or not, how to pay when you don't have money, how to pay, and all that. In some cases, even I have seen that resolution plans include a provision that this regulator fee is part of the CRP cost and we will pay it. But when actually the point of paying that fees comes up, people ask, "Are itna paisa dena hai? Kyun dena hai? Kisko dena hai? Ye kaun hai? Kya hai?" They don't know the answer to it. And so I would always suggest you to educate the resolution applicant about the possible quantum of that regulator's fee. And please remember that regulator's fee shall be payable when the proceeds means total resolution plan amount is more than the liquidation value of that particular asset. So it is for the RP to calculate it and see to it that the compliance is made. Nowadays, many cases, the RPs continue as a member of the monitoring committee. So it will be upon you only to comply with this particular provision and see to it that the payment is made. You know the exceptions that if it is a project where the RA is allottees themselves, then there is an exemption. Otherwise, you don't have any exemption for the regulator's fees to be paid. If there is delay in payment, there will be interest payable, etc. So all that is there. There is not much complexity in this, but still, if you people have faced any issues in this, let us discuss further and knowledge of all of the people on the forum.
Thank you very much, sir, to open the forum. But I think
let me ask a question myself. If there is no question, how do you calculate total resolution amount if you are giving flats to the flat owners for which value is not determined? That is, you have a total resolution amount, financial creditors are being paid 100 crores and about 500 flat owners will be getting their flats completed. So there will be a certain amount being paid for that. Whether it will be part of the total resolution plan amount and whether it will be calculated towards the regulator's fee that will be charged. That is a question that comes to me many times.
Yes, a very interesting question.
Sir, I had a query, on Regulation 31A. If you permit me, I can ask the question.
Please go
Sir
ahead,
was
sir.
Sir was in the process of giving the answer of the question that he raised.
Yeah, sorry, continue. Continue,
Sir,
sir.
please
Continue.
Somebody was saying something. Ravin ji, आप कुछ
Sir,
बोल रहे
we
थे?
complete the answer to the question that you just raised, sir, and then we take up Vikramji's.
I was just waiting for one answer to one of my questions
Ji,
rather
sir.
than me giving an answer. रविंद्र जी, आप कुछ बोल रहे थे?
उनका कोई सवाल है सर, वो आपके सवाल का जवाब नहीं दे रहे थे.
ठीक है, मैं मेरा सवाल बाद में देता हूँ. Let us first listen to
I
Vikram ji.
understand your question. In my understanding, if whatever the resolution applicant has to pay to complete that project before giving the handover to the home buyer, that component should be considered as a part of a contribution by the resolution applicant, not the whole value. Suppose the project is 80% completed and he has to pay 20% amount to complete that project. So that 20% component plus whatever he is paying others, that should be considered as a part of to calculate the fees. I
will ask a flip question that 20% is going to be contributed by the flat owners themselves, against which he will complete it. So what is being paid to them?
So there are a situation where the home buyer has to pay only 5% and he has to he is required to make 20% contribution for the balance construction work. That possibility may be there, na sir? I understand.
Some people even have a question or a stand that if 80% is already constructed and that is their claim which is being returned to them, why not it 80% be considered as a resolution plan amount? Like the financial creditors gave loan and these people have filed a claim. So if the claim is 200 crores and the financial creditors are being paid 100 crores, why not the claim of allottees of 200 crores be considered as the resolution amount? That is the question. I don't have an answer for this. I will be very frank. I leave it to the concerned CIRP RPs to make the working. Nobody has raised a question about it, but I personally feel that we should get some clarification from IBBI regarding how to calculate resolution amount in such cases. Either get an exemption for the LOT part or how. So
Thank
that is my humble
sir. We will
suggestion.
put up this question to the IBBI and we will try to figure out the solution, sir. Thank you so much for this question, sir.
विक्रम जी, आप कुछ पूछ रहे थे?
Yes, sir. So on Regulation 31A, there are two parts: regulation subclause 1 and subclause 2. So on subclause 1, 0.25% of the resolution value has to be paid as a regulatory fee. Now, you can take it as a question, you can take it as a suggestion. The point is putting an onus on the RP to collect the regulatory fee for IBBI. It would have been much better if this fee could have been paid directly by the resolution applicant to IBBI, so that it was not a part of the CIRP cost, number one, and this would not have been a burden on the IP to do the compliance. That is with respect to 31A subclause 1. Now, my major issue is with respect to subclause 2. Now, 1% of the cost incurred by the IP in the CIRP cost has to be paid to IBBI. Sir, my point is, in every CIRP, major amount of the fee is pending of the IP itself. We are not able to pay to the advocates, we are not able to pay to the IP himself and to large number of service providers. So our priority is to make the payment to the professionals engaged by us and not to make the payment to IBBI, because the resources in our kitty is very limited. Now, as a result, what happens? Regulatory fee gets pushed back and interest gets piling up. My simple, humble submission is that we need to press IBBI that please delete 31A2 don't put this burden on the RPs to collect the fee for IBBI. When we are not able to collect our own fee, why should we be burdened to collect the fee on behalf of IBBI? And that too with interest. If IBBI wants interest, then they should also have a provision of interest on the late payment of fees to the RPs. I find this provision to be, absolutely absurd.
I would try to address this in a different way. I have seen many IPs who are even MSME, and they are not paid that MSME interest also. Even if you are getting 18% MSME interest, it is good enough. पैसा रहने दो 2 साल बाद मिलेगा तो भी चलेगा. That is some IPs may say, but that is on a lighter note. But 31A2 is using the language cost being booked. And when we go and file the return for the fees, they say CRP cost paid. I don't know how many have caught this difference between the wording. In the return that we file with IBBI for payment of regulatory fee, they use the word cost being paid. And in the regulation, the word is cost being booked. Now, booked means accrued and paid means actually paid. So that difference remains. I again request IPNet to raise this differentiation between the language as to why are we using the word booked in 31A2 and why are we using word paid in the return that we are filing. Because paid can be very less and can be zero also. But being booked is very high amount. So that difference remains. And as Vikramji has just said, the model guidelines of COC may be modified to an extent now that at least the cost of the professionals that they have approved fees for should be paid from out of interim funding. Interim funding is another subject for another day, but we can put up that question also in our mind. I think we are at 6:12 now.
We can take one more question, sir. Just one more question. Mr. Raj Kamal Sarogi has been on mute for a very long time and been waiting.
Sure.
Can somebody? He's also raised his hand. Can somebody unmute him, please?
Yeah. I've already unmuted, I think. Regarding regulators' fees, with regard to the home buyers, the claim filed by them is parallel to the claim filed by the financial creditor. If we compare the CRP process in case of non-realty cases, then the regulator fee is being calculated on the amount being received by the claimants. In case of home buyers, they are receiving the full claim amount if the home is being given. So in that case, the claim amount should be the value which should be the base for the regulator's fees. That I think there cannot be a better alternate than this amount. If you compare the different situations,
better alternate could be not paying fee on that part only by amending that regulation. Otherwise, as Raj Kamalji has stated, the claim amount which is received is what these flat owners get back. So, of course, that could be easily termed as the part of the resolution amount. So that is a very good interpretation, and I also have a similar interpretation, but that would increase the resolution amount and the regulatory fee to another level itself. I think
my suggestion would be that an immediate clarification may be issued by the IBBI regarding the model of calculations, how these regulatory fees should be calculated, on which amount, but what is the realizable value?
I would suggest that we should seek for an exemption, because in case of a resolution plan which has been submitted by allottees, there is exemption to the regulatory fee. So even the claim can be exempted accordingly, so that it will be easier to, or the burden of the resolution applicant will be reduced to that extent.
That can be said, but whatever thing is there, that should be a proper clarification from the IBBI to avoid any confusion.
Yes, so that we as IPs and liquidators should not be in trouble that why did you do this calculation in this manner and you have done it correctly or incorrectly. We will not be blamed.
And
Yes.
once the clarification comes, then the resolution applicant may be asked to pay directly, as Vikramji has suggested. I fully endorse his view that it should be paid directly by them, and the timing of the payment should also be mentioned in their resolution plan when they are going to pay the regulatory fees.
We had in mind to also touch upon various compliances that we
Sir,
have
one
to
more
do
question.
under.
See, if the
Yes, sir, yes, sir.
resolution plan amount is slightly above the liquidation value, then on the entire amount that difference need to be paid. See, your
Yeah, even 1
liquidation
rupee.
value is 1 crore or 10 crore rupee, and if your plan amount is 10 crore 1 lakh rupee, then on the entire 10 crore 1 lakh rupee one has to pay. And if it is 9
Yes.
crore 99 lakhs rupees, then nothing needs to be paid. So
Nothing
that
needs to be
on
paid.
yeah, it is only should be on the differential amount and it should be charged, not on the entire amount.
So
That
then
also
the
suggestion the
formula
IPNet can or you can consider for the
you are asking for a difference of 1 lakh or 10 lakh. Even if it is 1 rupee, it will still be attractive.
I have given an example.
Yes.
Even if it is 1
Yes,
rupee,
yes,
it
yes.
is payable. The entire amount becomes payable, and especially the resolution applicant don't know the liquidation value. So he and the maximization of value, the COC always tries.
So based on what we can suggest is based on the difference between liquidation value and the fair value or the value of the plan, but they will charge far more percent of the difference amount instead of 1%. But of course, that can be worked out by expert at IPNet and a suggestion can be made. So
This is my
that
suggestion
is
from my end. Actually, okay, it is not going from IP's pocket, it is going from the RS pocket, but it is ultimately a fair. I think it should be a suggestion.
We wanted to touch upon one more topic of compliances under Companies Act, EF Act, ESIC Act, etc. But I don't think we have that kind of time on hand. So we will save it for some other day to be discussed. And back to the moderator to decide the course of the action for this session. Thank you very much.
Mr. Patwardhan, I think there are few hands which are being raised. So I think you can quickly take
Yeah.
those questions. I think Mr.
Yes, we can. Sandeep ji is there.
Yeah.
Praveen ji, we just addressed.
Yes, yes.
Sandeep ji is there.
Correct.
Sandeep ji, please.
Yes. So as per Regulation 4 of liquidation regulations, so if a liquidator is being paid fees as a percentage of realization and distribution, so my question here is that let us say if some kind of realization is expected from Section 66 application, but that takes time, and let us say the company is dissolved prior to that. So how can that very fees be fixed, or will that be basically on the whims and fancies of SEC only, or are there any regulations which can be taken into account for that?
The Regulation 4 does not specify as to how the assets are realized, how the realization happens from the assets of the company. So when there are likely recoveries from any of the avoidance applications, let it not be left to the, I would say, 11th hour decision. I will not use the word whims, but 11th hour decision by the COC at that point or the SCC at that point. Instead, it is suggested that appropriate provisions regarding the calculation or inclusion of such recovery in the fee itself can be made when the fees are being decided. So that is a possibility. For example, if a company's assets are sold to a person at an undervalued amount and that recovery is made, so it was certainly a short realization of the company's asset, which was made up later. So I would always call it as a realization of company's assets. Or if there is a fraudulent transaction done under 66(1) or 66(2) and company's monies were diverted out which were taken back. Again, I will say that it was company's assets which was realized. So there is a fair possibility of calling the the avoidance applications recovery as realization, no doubt about it. But there will be a lot of questions asked as to who did really take the effort to realize these assets, how much liquidator was involved in it. So all these questions will be asked, but it is better to not to leave it to the SCC to be decided when the recovery is made. If it happens after 4 years, nobody is going to look at the liquidator when the dissolution has already happened. So you will not be able to recover something at that point by raising a hand. That all will have to be discussed while the liquidation is going on or when the liquidation is being proposed under the CIRP itself. That is my take on it.
So there is one
That
last
is the practical answer I am trying to give.
There is one question which says that as per the new regulation, IM is to be published within 95 days of CIRP commencement. But the CIRP 3 shows the delay if we file it on the 95th day. Which one is the correct one?
There is a problem of a day, but in that case, how do you calculate the days is the question. Some forms calculate the ICD as day 1 and instead of day 0. So such problems do arise. In such case, the delay will have to be accepted. You will have to write to IBBI that this is the calculation which has gone wrong and this should be taken as the correct filing. Please remember, that is only reporting being made to IBBI. If you did publish the IM within 95 days, you have complied with the law. What you are doing in the CIRP forms is only a reporting. That does not make your act of publishing right or wrong. So go with the regulations. That is what you have to follow. The forms could be wrong and you will have to write to IBBI for any corrections.
Thank you, sir. There are a lot of suggestions, sir, which says that for liquidation, we need another session because liquidation forms are quite vast and they want some more sessions on it. So I would request IPNet to, shall consider one more session on the liquidation forms on compliance.
Bharti,
I request Ravinji, Ashishji to please consider this, that somebody can address this because 30th September is the last date and people will need some guidance and discussion on this.
Yes, sir. It is very important.
Bharti, you don't have to request IPNet. You are part of IPNet.
Yes, sir.
But discuss with your
So I did take this. Yes, I did take this note, sir, that this is very important. Before 30th of September, we need one more session on the compliance, specifically on the LQs.
Correct. Let's do that. Let's do that. I think we will discuss in our regional meetings also, and I think Ravinderji can take it up. Wonderful.
Yes. Okay, thank you. Yes, sir.
Thank you very much, sir.
I thank Mr. Patwardhan for his valuable suggestions, his information, his understanding, and explaining each and every question to its core and addressing them very, very well. Thank you very, very, very much, sir, for taking out time for our members, and they were enriched with your knowledge. Thank you.
Thank you. Thank you very much, everybody. Dr. Makhija,
And just to
Ravinji,
add, sir, Udayaraj, sir,
everybody.
you are so prompt and immediately accepted our request. I always heard many seminars chaired by you. So thank you very much from our side too, from IPNet side. I really think that you have took a time and we are looking forward on the one seminar on liquidation forms. So we will again disturb you, sir.
Anytime, sir. Whatever is needed, I am there for the fraternity. It's a very good initiative that has been taken by you all, led by Dr. Makhija, and I am really proud to be associated with it.
Thank you, sir. Thank you.
Thank you, sir.
I now request Bharti to please present an appreciation certificate to Udayaraj, sir.
Thank you very much, sir, for being the lead speaker. And it was a great session and completely honored to be here and be part of listening to you for the questions.
Thank you very much.
I will send this fully framed to your office, sir.
Sure, sir, sure.
Thank you.
Looking
Thank you.
forward to it, sir. Thank you, sir.
And a special thanks to Bharti ma'am for being a great coordinator. Parag sir, please give appreciation certificate to Bharti ma'am as well.
Bharti, thank you very much for being part of IPNet and moderating in such a wonderful manner. The entire session went smooth, and we look forward for your immense knowledge and experience in being moderator in incoming sessions also. Thank you very much.
Thank you very much, sir. Thank you.
And this certificate.
Honor was mine.
Yeah, this certificate will be handed over to you in physical form, duly mounted by Ravindra Chaturvedi.
Ji, sir. Thank you so much, sir.
Thank you to all the participants for your patient hearing. And with this, we conclude our first webinar at IPNet, and a special thanks to the IPNet fraternity for giving us the opportunity today. Now looking forward for more such webinars, and hence I would like to invite Mr. Ravi Chandran for announcement of our next webinar by IPNet South. Mr. Ravi Chandran?
Any which way. So next seminar we are going to conduct on 21st of September. It is to be hosted by South Zone of IPNet. Can I, Ravi Chandran sir is there?
Yeah, I'm here actually. Just my this was muted. The next topic is challenges faced by IP relating to employees and operation cadres under IBC. It's a very interesting topic, and a very interesting speaker is there. So I request all the IPNet family to be there on next Saturday at 5 p.m.
And Mr. Ravichandran, you have to add that we have invited Mr. V.K. Gupta, the former member of NCC, as the chief guest for his keynote address.
Yes, sir. Yes, sir. Keynote address actually. He requires no introduction, and we will all certainly learn from him actually.
Friends, I must say that every week, you see, on every Saturday between 4 to 6 or 4:30, whatever the time is, IPNet is going to hold wonderful webinars. Please block your calendar for all Saturdays between this time. Okay, Namrata, over to you.
Thank you so much, sir, and our best wishes.
So today was our first IPNet webinar, and I must say, and thanks all the participants first. Otherwise, it is without participation, the even speakers and we also being discouraged. So first of all, thank you so much for such a large participation. It was reached to 120. Second, I really thankful to our president who has taken this initiative, and we are looking forward under his leadership to take at the next level where the IP can raise their voice and we can raise all our questions to IBPI, IIIPI, whatever the forum, and we can get the clarification. Third, that the speakers today was really enriched our knowledge. Udayraj sir has given best of his guidance on regulatory compliances. Thank you so much, sir. And Sahu sir is already took an exit, but no doubt his 10 minutes or 20 minute presence is absolutely always wonderful. Whatever word he speaks is every word is very useful to hear it out.
Mr. Chaturvedi,
thank you everyone.
Mr. Chaturvedi, I must interrupt and tell you that Dr. Sahu is still here.
Still there.
Oh,
yes.
Sorry.
All right. Thank you so much. Thank you.
I think
sorry.
Such a dedication, and he went through the entire all words which were. So thank you, sir.
We have seen him since 2016, and I feel like touching his feet whenever I see him. Honestly speaking.
No, I think he really deserves that. He really deserves that.
Yes.
Okay. So friends, before we part our ways, I must tell you one thing. We have got theipnet.com specially made for you. Please explore. Please use those, look at those functionalities. Please use those functionalities. Clarify your doubts. If you have any doubt, put it. We will put it to the expert committee. This is what Dr. Sahu suggested. We already have that feature. You can join study groups. We have 11 study groups of various kinds, starting from CIRP going up to policy advocacy. Please join study groups of your choice. You can share your experiences. We need only 2 paragraphs. What was the problem faced? How did you resolve that? Share it. We will publish it on the website with your name. We have already done that for almost around 20 people. You can go and explore those experiences. I think what we need to do is, as senior professionals, we must hand over that knowledge. Right? Everyone should not keep it as a secret. Share that knowledge with everyone. Give it to the next generation or the new IPs. I think the IPs, the insolvency professional world, will be the best place to live in, isn't it? So friends, with these words, I must thank you from bottom of my heart to join in such large numbers. As Ravinji also said, I think we are deeply, deeply grateful to each one of you. Thank you so much, friends. Thank you.
Thank you.
Thank you, everyone. Thank you.
Bharti madam, thank you. Sorry, I have forgot to.
No, sir. Absolutely fine. Absolutely wonderful session. Somehow
Yeah.
my video is, I don't know what's wrong with my video. It is still, it's on, but I can't see my own self.
It's okay. We can feel your presence. Don't worry.
Right.
By your voice.
I'm so sorry about that.
See everyone next week now. Thank you so much.
Yes, sir. Thank you, sir.
Thank you. Thank you.